I request our project fellow Bhargav Valanzu to introduce the associate institution Siddhanta Knowledge Foundation. Bhargav Valanzu.
Namo Namaha. I will be briefly introducing Siddhanta Knowledge Foundation. So let's begin. Siddhanta Knowledge Foundation, SKF, is founded by Shri Jai Kishan Javer ji, renowned industrialist based out of Chennai, Tamil Nadu. In addition to research collaborations with reputed universities, SKF is also publishing important literature in Sanskrit and other Indian languages through SKF Prakashan. SKF has recently published an important 2-volume primer on Panini's Ashtadhyayi written by Dr. Tilak Raoji called Ashtadhyayi Pravesha. SKF is also involved in supporting Veda Pathashalas and Gurukulas, designing online courses and textbooks for students, digitizing rare and ancient books, koshas and palm leaf manuscripts, and organizing talks, lectures and seminars by reputed scholars in various fields, highlighting our Bharatiya thought process. On behalf of KKSU University, I would like to say we sincerely appreciate your contribution for the purpose of organizing this conference. We are absolutely certain that the presentation on Dharma Shastra in this august gathering of scholars are going to be impactful, and that these discussions will pave the way for a Dharma Shastra oriented thought process in various fields of application, not only in Bharat but for a global perspective. Dhanyavad.
We will be just discussing various relevant topics, and I know that amongst the audience also we have very good scholars of Dharma Shastra and general understanding of our customs and all that. Like good scholars are there, Deshpande madam and Namzushi madam, Kalacharya madam, Thite sir, Mule sir and Marathe sir. So there are scholars. So this is a discussion, and in order to make it very fruitful, I request you also can participate because it is for us, for all of us. So here, general one point will be there. We will be discussing, some experts are sitting here, they will share their knowledge. And whenever you feel that something can be added to that, please participate with permission. And together we can make it more fruitful. So this is the idea behind the panel discussion, and especially the concept dharma is very wide and deep. So therefore, don't limit yourself to whatever you have studied in the text, like dharma is this, etc. It has a wider connotation, and it includes various practices, that means social practices. It includes some banned things also. It includes some forgotten laws. Because in 1850, 1875, 1890, 1916, various Hindu laws were made. And later, very typically, the British government had forgotten the Hindu laws, or they depended more on the translations provided by Colebrook and others. Perhaps there were 2 such translations were available, and therefore the British government had to depend on that, and therefore some laws were twisted, some were misinterpreted. And even the Hindu scholars, even in the modern Ayodhya, Ayodhya issue also, that Supreme Court Justice he was discussing, that on one side you have good scholars of Sanskrit who know Sanskrit, who can quote from Sanskrit texts. On the other side, there are some lawyers, or you can say the representative of other sections, they don't know Sanskrit, but they want to refute. So that is the problem when there is no proper coordination, when there is no dialogue at all. So how can you say that the proper justice can be done? So that problem has been highlighted in the British era also. That was there prominently, and that's why even our Bharat Ratna P.V. Kane sir felt, somewhere he remarked that the Hindu jurisprudence, Hindu law needs to be codified, and various things are to be resuscitated, need to be enlivened and put into the proper format, structure. So with all this in mind, we have arranged the panel discussion, and I'm very happy that Honorable Joshi sir, Ambadas Joshi sir, he himself is present here, and we can have good input from him. And on my right side, Professor Anagha Joshi madam is there. She is professor in Sanskrit from CAS, Center for Advanced Studies in Pune University, and she has worked on Dharma Shastra. And we have with us eminent Mimamsa and Dharma Shastra scholar Professor Kashinath ji from Nepal, and we have our foreign guest scholar Iturbe sir. So all these will give their input, but at the same time I appreciate your participation, your input, and let us make it so lively that it will not be a formal panel discussion. So thank you all, and at the outset I request Professor Anagha madam to start the discussion.
To continue with Professor Penna's sir's speech, I would like to quote from History of Dharma Shastra, Volume 2, page 2 quotes, means P.V. Kane quote, "The conception of dharma was a far-reaching one, and it embraced the whole life of man. The writers on Dharma Shastra meant by dharma not a creed or religion, but a mode of life or a code of conduct, which regulated a man's work and activities as a member of society, as an individual, and was intended to bring about the gradual development of a man and to enable him to reach what was deemed to be the goal of human existence." And now the topic will be custom. So from this point of view, I would like to say something about customs. Sorry. Hindu law primarily known as customary laws. For example, customary rules could tell us that when a man dies, his property should go to his son. But if there is no son, then who will inherit the property? This was not answered by custom, and this requirement was fulfilled by the Smritis, commentaries, and digests in ancient India. I will give you only one example, that Yajnavalkya in Yajnavalkya Smriti has given the order of succession of a person who has no son and has departed for heaven. The order is his wife and the daughter, both parents, then brothers, sons, etc. On failure of these, that is wife and daughter, the parents, that is the father and the mother, are successors to the property. Here, in the absence of the daughter, parent right of succession is laid down. However, the question arises whether mother should be preferred to father or vice versa, or whether both the parents take the property jointly. In the English translation by M.N. Datta, father is given first in the list. But the commentary Mitakshara prefers the mother to the father, and to support his view, the commentator Vijnaneshwara comments three possible interpretations. That is, Dvandva Smaranat, Tad Apavadatvad, Ekasheshasya Dhanagrahane, Pitroho Kramaha na Pratiyate, Tathapi Vigraha Vakye, Matrushabdasya Purvam Shravanat, Prathamam Mata Dhanabhak, Tadabhave Pita iti gamyate. In dissolving the compound word pitarau, the word mata comes first. Even when the ekashesha compound is not used, as in the case mata pitarau, the word mata comes first. And in the case where a man has several wives and several sons by each wife, the propinquity or closeness between a particular son and his mother is greater than between him and the father. So kincha pita sapatni putreshu api sadharanaha mata tu na sadharani iti pratyasatti atishayosti iti. So Vijnaneshwara states that because the father is a common parent of all and the mother is a particular parent, the rule of propinquity, nearness alone has the final determining factor for the mother as a preferential heir than father. So therefore it is more proper that the mother should take the property, and on failure of her, the father is the successor of property. So
very nice, ma'am. Very nice input. But with reference to this, I would like to bring to your attention, notice that Vijnaneshwara, while commenting on this, he refers to the Mimamsa Nyaya, Arthakrama and Shabdakrama. So this is the Mimamsa principle they have applied. And Viprakarshat Paradaurbaliam. So this is Viprakarshat Paradaurbaliam means when there is no nearness or proximity, then the later one becomes weaker. So the strength of a particular argument depends on the proximity of that. So that also they discussed, and Madam said this parents, Mata comes first, and therefore the verdict is given on that side. So this is real good observation, sir. And in this regard, I request our Honorable Sir to comment from the Western perspective or modern perspective.
Since the discussion is open on the term custom, I am not driven to focus it barely from the point of view of succession. Succession is one aspect where the custom matters. What happens about the custom of adoption? What has to happen as to custom relating to certain rites to be performed in the marriage? So whenever we bank upon the concept of custom with regard to unwritten, uncodified Hindu law, codified from the perspective codified by contemporary legislature. I do not mean to say that law recited in the ancient text is not codified. There is tremendous possibility of tremendous variety. Therefore, we distinguish codified and uncodified law from the point of view of law-making authority. These Rishis who have written the treatise were academicians of acclaim and study, and they have put on record their commentary, which, having been followed for long period, immemorable period, gained the status of law. But once the British rule came and natives, particularly Hindu reformers, demanded the variety to be narrowed down, and with an object of bringing uniformity in relation to certain matters of personal law of Hindu community, codification was done. Once the codification is done, except for academic purpose, ancient texts do not carry any value except, what is this exception? Except law itself saves the custom. To my knowledge, there is at least one such provision. In relation to the adoption, the age limit, difference of age between the child and the parents adopting the child is a mandatory rule, but exception has been provided. Except there is a custom otherwise in existence. But now it's a great puzzle for me with my 71 years of age. How can there be a custom in a family of adoption? As if the family does not conceive a child at all. Dasharatha did not have, okay, good, he had it after Yajna. Assume he did not get it. Then have one adoption. Then adopted son Sri Rama would adopt another child. Then Sri Rama's sons would adopt child. Impossible. So you have to trace existence of custom by enforcing and relying upon rules of evidence. Yes, therefore whenever we talk about rules of evidence, we come back to the contemporary rule of evidence and not the ancient rule of evidence. If ancient rules of evidence are there, to my haphazard knowledge, I am not claiming mastery on ancient law. Except Manu, nobody has commented on rules of evidence. And when Manu comments on rules of evidence, he says same thing which has been said in British made Evidence Act. What can be proved by documents is not to be proved by oral evidence. This is the modern Evidence Act. Manu says same thing. Document preferred by oral evidence. First hand witness preferred by secondary evidence. Modern law says same thing. Evidence of interested persons and relatives would be assessed with caution. So custom becomes a product of what is proved according to law. Now there will be one more thing which I must mention here. Custom inter se the relations between the family members is one thing. Another thing which is not considered to be Hindu law. Not Hindu law, I am specially mentioning because I had contributed something in relation to Vishwakosh. What are the religious practices, not the Hindu law? What are the customs in a temple is not the Hindu law. What shall happen? There was a question which was going to be asked, which I am anticipating and answering. What shall be the mandatory rites to be performed post-death? Whatever, to my humble view, whatever is prescribed by law, either codified, uncodified, ancient or modern, which relates to human life, property, succession, which we call in vernacular language, Sanskrit, Marathi, any language, aihik, whatever exists during your lifetime and relating to your property, relating to living beings, these are the matters of law. What shall happen to your soul can't be a matter of law, no tradition, no custom. So what shall be the final rites to be performed may be governed by law if law is laid down. Secondly, if law is not laid down by law, saved by codified law, and if not, none. It's a matter of faith than the law. I think I have tried to come nearby the question. If something more is required and if I can enlighten or anybody in the audience can do, please do it.
Now I request Kashinath sir. If you have anything to add, we'll be glad to hear you also. Somebody should be there to coordinate.
Please hand over mic.
Hannah?
This is Dr. Kokila from English and Foreign Languages University, Hyderabad. I have seen one case, Captain Raja Rao, Veera Raja Rao, who was a martyr in Kargil war. He is from Hyderabad, very near to my place. So one day I visited, on one Independence Day, I visited his place. To my despair, I found that after his martyrdom, he was very young, maybe perhaps 25 years of age, and just married, perhaps without any children as well. So whatever the benefits were there, they were given to his wife, and his wife left the parents. And the parents are very old now. So they don't, and he was the only son. So they don't have anything to back up on. So that is the plight of the parents now. So, what does law say about this? Is because these are very, very practical thing which we have seen, and especially regarding to the martyrs and their parents who lose their sons in such cases. Thank you, sir.
Any ancillary question? All right. Let me clarify one thing at the outset. There is a concept of self-acquired property. There is a concept of self-acquired property. Is it clear? Is the word clear? Yes, there is a concept of self-acquired property. If the martyr had nominated his wife to receive or to be entitled for the entire money which he had to receive post his death, she becomes absolute owner. And it is a matter of duty than a right. This aspect of duty I am going to deal with given an occasion during this discussion itself. It's a matter of duty than a right. And very funniest part which I mentioned at this stage, though I was supposed to do it if a question comes, entire Western jurisprudence, starting from the first law made by them in India, first civilian law, that was made in 1872, Indian Contract Act. Their vachan, promise, was defined. Promise enforceable in the court of law, which courts can enforce, is the only promise which can be enforced. And this is the representative of entire Western or English jurisprudence. What can be done through the court of law alone can be done under Western law. There is nothing like personal obligation which is fastened not to the individual in this incarnation but in innumerable post-incarnations. His Atma is not relieved. So, Bhautik, not Adhibhautik. Entire contemporary jurisprudence is based on Bhautikta and not Adhibhautikta. That is the limitation of law. Your problem is of the plight of the parents. Adhibhautik point of view, the lady will have to face after her past, after death, or maybe during this life also, depending on her accumulations of earlier births. But law is too short to take care of this. Therefore, Shravan Bal is a legend. One doesn't know if that is the reality. So, no, helpless. There is nothing to be done. No, got it. Got your point. See, no, you are demanding the law. How we differentiate is like this. You say demanding, don't say it, you are demanding, I am demanding. Why not? I had argued one case, you may love to listen to that case. One soldier, after retirement, was involved in a criminal case, in political matter. And his pension was forfeited. I was fighting the case for that lady. My argument was that I have served the family and parents of the soldier when he was on the border, and his pension is my indivisible right, and I lost the case. Question is of provision of law being made, and provision of law what ought to be. We are talking of ideals. It's not there, unfortunately. Let us demand, and maybe government would provide for it.
Madam, your argument, Mata comes first in the Vikravakya, therefore she has more rights. I'm sorry, I don't know whether it can be accepted. Left to myself, personally, individually, I respect my mother more than my father, but that's a different story. But in a Vikravakya, between the Vikravakya and the compound is more powerful. The compound is a speciality. Samasa is a speciality in Sanskrit. Therefore, it has more power. We don't find so much of compounds in any other language. Therefore, how the compound exists, that gives us an idea. Mata cha pita cha, you don't say mataro. You say only pitaro. Therefore, just because in the Vikravakya Mata occurs first, it doesn't mean that it has more, she has more rights.
Yeah, thank you. This is a good thing. Just I want to say about because we are in the Kalidasa University, so same thing. I am going to repeat that. Vagartha vivasam priktau vagartha pratipattaye jagatah pitaro vande parvati parameswaro. In this opening verse of Raghuvamsa, very famous Kavya of Raghuvamsa of Kalidasa, there is just first he put the vak. This is the feminine word, vak, speech. Artha is meaning. This is artha, masculine word. Vagarthau iva sampriktau. Vak artha pratipatte. Again he repeated vak and artha pratipatte means knowledge, to get the knowledge, to know the vak and speech and their meanings, speeches and their meanings. Jagatah pitarau vande. Pitaro, Jagataha Pitaro, Vande Pitaro. The same thing there is the Samasa, Pitaja, Mataja, Pitaro. And if maybe there's the Pita and Mata should be there, but no, because after that suddenly he used the Parvati, this is the feminine, Vak feminine, Parvati feminine. So Pitaro, there is the feminine word means Mata, mother, Parvati and Parameshwara Shiva after that one thing, this is okay. But I have one small question, because in judiciary system of Indian penal code, or this is the penal code is the new word, but Indian judiciary system, ancient system, which we can, there is behind of it there is the dharma, and for the dharma there are 4 evidences are there in dharma behind of it. Shrutihi, Smritihi, Sadacharaha, Swasya Priyamatmana. Shruti means Vedas, Smriti means other texts, Smriti texts, Shruti, Smriti, Sadachara is good conduct, and Swasya, there is a last one, the Swasya Priyamatmana, which is, we accept, is a good, Viveka. And this is the accepted in the modern system or not, this is the question. And I can supply the other from the Kalidasa, because we are here in the front of Kalidasa. Yeah. When Dushyanta was there in the forest, and he saw the daughter of sage, and he thought that this is a very beautiful girl, but I am Kshatriya and she may Brahmin daughter, so how it is possible? But finally he thought, according to Kalidasa, Satam hi sandeha padesu vastusu pramanam antah karana pravritte, same viveka. It is accepted in now or not?
Yeah, thank you, sir. And actually, we have been discussing law on issue of customs and traditions in religious practices, and this is not just limited to inheritance, dayad, etc. There are so many other, and we have recently witnessed this Shabarimala case. So several such cases are there where Dharma Shastra, has it got something to say about it? And of course, great thinkers have been working on that. So let us open that for discussion. And what sir said, that Mata Pitaro, Mata need not be taken first, but Mimamsakas are very particular. They say Pashuna Yejeta. If you say Pashuna Yejeta, if you take Pashu, any Pashu, they say no. Because Shabda Pramanaka Vayam, Shavar Bhashya says, we are Shabda Pramanakaha. And there, Pashuna Yejeta, that Pashu, after that Na is there. And we all know that Angon Astriyam, that Panini Sutra says, Astriyam Na. That means the Na is added to the word in other genders, not in feminine gender. So therefore, feminine Pashu is not to be sacrificed. So that is the meticulous, very subtle, Purusha Pashu. Don't say we are all Purushas Pashu. It doesn't give the sense. So don't feel very happy that all Purushas are Pashu. So here, the male Pashu, male animal we can say. So the male goat, not the she-male. So this idea is there. So we go ahead. Definition of the term Hindu. And see, we all know what Hindu means. Hinoti, Dushtan, Dusheti, Iti Hindu, etc. There. These are not in the ancient text, but still we depend on them, because when there is no other Balavattara Pramana, whatever Pramana is available, we have to accept that is the tradition. And in this background, I would like to request our Iturbe sir to share his idea. What you understand from the word Hindu?
This, not an easy question, but it's interesting because in Spanish the word Indian is used Hindu, no? He's Hindu, and a Spaniard will say he's an Hindu, means he's an Indian. No, does not refer to the religion, refers to the nationality. It's pronounced like that, not Hindu, but Hindu. No, the H is silent in Spanish. So, but if we say who is a Hindu, I will first think a person who practices Hinduism as a religion. If I'm talking who is an Indian, who is a legitimate citizen of this country. That I think is my reply.
Thanks a lot, sir. As actually, this has some linguistic affinity also. That Sindhu, whoever settled on the bank of Sindhu river, they were called as Hindu because Sa is pronounced as Ha, as we all know. In Zoroastrian text also, that is a regular linguistic feature. Saptaha is known as Haptaha. So we all use that, Ek Hafta, Do Hafta. So that actually comes from Saptaha. Sindhu is there, Sapta becomes Hafta. So all this is there. Sir, thank you so much. And yeah, sir wants to share one shloka.
This about the Hindu, there is Ashirvadam na grinhiyat marusthala nivasinaha shatayu iti bhaktabbe hatayu iti sampadet.
I think you understand the shloka. He says, Ashirvada na grahitavyaha smashana nivasine. Marudesha nivasine. Marudesha nivasine. Again. Acha. So maybe Purva is Maru because China, etc. So he says they may mispronounce it. Shatayu may become Hatayu. So that is the problem. And we all know that a lot of importance is given to the pronunciation, the Veda. So this is the background, and now we just discuss Dharma Shastra perspective in case of conflict in following Dharma and law of the land. This is very subtle because the courts are also struggling, and see, several such customs are there. People are approaching courts for justice, and on one side you have the practice, on the other side you have the court. So people are providing all necessary evidence for that, but still Dharma and Nyayalaya. So some distance is there. I request Joshi sir to throw some light on this, sir.
See, aspect of Dharma, to my humble view, is focused having 360-degree spectrum. It is basically focused on duties which are material and eternal. Material duties refer to reciprocation of rights of every individual around you. Ahimsa is an eternal dharma as well as a material dharma. Aparigraha is a material dharma as well as ethical and mental and metaphysical dharma. In the morning only I was discussing with reference to intellectual property. And I had referred to Yogananda Saraswati's book, Autobiography of Yogi. There he had referred to Sharat Chandra Bose, who was a scientist who did not acquire or apply even for one patent. What do you do by acquiring a patent? You amass absoluteness of rights in relation to something which pre-existed and you claim to have invented it, and take away rest of the world of rights of its use and make it available only on payment of monetary consideration to you. This is the best ever example of violation of rule of aparigraha, materialistically as well as metaphysically, eternally also. So if we look at Indian jurisprudence as I describe it, it's embarrassed in one word called dharma. Its correct connotation, as I understand, is duty, as I already mentioned and I have repeated now. Now question is, does Dharma Shastra also describe numerous rights or not? Answer is an affirmative. And my submission is that rights have been enumerated and enlisted. I'll repeat these words, not for the sake of clarity, but for my satisfaction. Rights have been enlisted and enumerated in the Dharma Shastra, not for their recognition, but for illustration of what duties are. This is exactly contrary to the Western jurisprudence, where entire jurisprudence is based on rights and enforceability. all that I mentioned in 1872 law, first law relating to contract that was enacted, there is something described as reciprocal obligation. If I go to the shop, buy something, declare my intention to buy, question is who shall pay first? Or goods should be first delivered. Law says that we'll look at the terms of contract and decide the sequence and order of performance. If the agreed sequence come, pay first and delivery later on. Delivery later on. That is the order of performance. Here is a duty to pay first and recover later. The right becomes contingent on performance of duty. But if you go as a Purohit for performing puja, how much dakshana you are going to get is not known, nor it can be contracted out. You have to perform it. Give Ashirvachan and don't ask for dakshana. That is the duty of the host, to give it. Your duty is to give Ashirvachan without consideration. This is how the duties in Dharma Shastra are described. And rights are left contingent on your destiny. That is Paralokikta. So I see to dharma and justice from duty point of view. If we go to linguistically, approaching the word justice, see, once you go to linguistic, you don't have to bank upon Western philosophy of justice. What in modern times Amartya Sen wrote in his book on idea of justice, in one word, great jurisprudence has been written in one word, not referred by any jurist later on. What is just? Whether your act is justice. Somebody does not study, father has spent money for study. What an angry parent will say, you have not done justice to the trust. Performance of duty is justice. Getting the fruits of somebody's rights is his destiny. Our present system also does not assure justice. One Dr. Kulkarni, who retired as the Director General of Police, wrote his book at his retirement. He gave 10 reputed is a bad word, well-published 10 criminal cases and put a question mark at the end. Accused were hanged. What did we give to the victims? Not even solace. So justice is a sort of a thing which is more fruitful if it is focused on duty than on right. Reaping of right is sheer personal gain, while performance of duty is writ large for the benefit of community. Therefore, justice from the point of view of Dharma Shastra is eternal as well as material based on duty principle. This is how I look at justice.
Wonderful, sir. Now, just coming to the other topics of the Dharma Shastra, I would like to ask Professor Anagha Joshi Madam about the gradation of courts and the vakil, advocates. So, Madam, can you share?
Actually, in Dharma Shastra, there is one verse कि नृपेण अधिकृताः पूगाः श्रेणयः अथ कुलानि च पूर्वं गुरुज्ञेयं व्यवहारविधौ नृणाम्. So, according to this verse, Puga is an association of persons resident in any town or village and from various castes and following different professions. Shrenis is an assembly of persons of different castes or one caste following a particular professions such as horse dealers, betel sellers, weavers and shoemakers. Kula is a collection of individuals who are related as agnates or cognates or by marriage, and Kula being an assembly of the kinsmen of the parties of the lowest court. So according to this verse, each succeeding one means officers appointed by the king, the Pugas, the Shrenis and the Kula, each previous one is superior in the legal proceedings between men. So in short, we may call it as gradation of courts. I don't know, means it is interpretation. And in Dharma Shastra, people used to ask that when at that time whether vakil is there or not. So the earlier texts of Dharma Shastras were not very explicit about law in general, but it seems that Narada was the first one to mention this institution explicitly, because in Narada Smriti it is stated as Arthina sanniyukto va pratyarthi prahitopi va yo yasyarthe vivadate tayor jaya parajayau. So it is clear from the above verse that two persons who carry on litigation for two other persons, one who is sanniyukta by the plaintiff and one who is prahita by the defendant. So both these terms are clear, which refer to persons appointed or proposed by either party. So it seems that Narada was the first who mentioned this institution explicitly. Thank you.
Thank you, ma'am. See, in the old text we have two words like Vakovakya and Pradvivaka. So Vakovakya is a kind of discussion, and Pradvivaka, the grammar texts explain that Pruchati iti Prat, Vadati iti Vak. So that is actually a prosecution and defense like that. So a person proposes and another person argues. So that kind of thing was there, and those words are used in Dharma Shastra. We have three parts like Achara Kanda, Vyavahara Kanda, Prayaschitta Kanda, and all these deal with Dharma. So when you study any text like Manu Smriti, Yajnavalkya Smriti, Atri Smriti, Bhrigu Smriti, monkey, that is, there is a Smriti, and Gobhila Smriti, Daksha Smriti, Vasishta Smriti. So in all these Smritis, with slight changes, the dharmas can be understood. But very luckily and very interestingly, some of the medieval Smritikara had added something new. Sometimes they deviated from the previous, and that gives actually a lot of fillip to us, especially when we study the Dharma Shastra text, that they had something to add. They had something to add in the benefit of the society. So now I request sir here.
This is apart from the Dharma Shastra. Madam, please tell us the secret of how you anticipated the question of Dr. Penna and come prepared with the answer.
They have given us questions, no?
Sir, I should have answered, but see, some of the questions were shared because there should not be any embarrassment. Sabha Maryada. So for that only, please. Marathi, sir.
नमस्सवायै अहम् एकः लघुद्यमी अस्मि संस्कृते मम अधिकारः नास्ति परन्तु अहम् एकं प्रश्नं प्रष्टुमिच्छामि मया एकं काव्यप्रयत्नः कृतः धर्माधर्मं समीकृत्य सर्व अधर्मसमानता देशे संजायते तस्माद् अधर्मनिरपेक्षता मम तात्पर्यमस्ति यदि धर्मं च अधर्मं वयं समीकुर्मः तर्हि दुष्टप्रवृत्तिः वर्धेत तेन तत् धर्मनिरपेक्षतायाः अर्थः एव निरर्थकः भविष्यति अधर्मनिरपेक्षता अर्थ भवेत् तद्विषये किञ्चित् चिन्तनं भवेत् धन्यवादः
कर्तव्यह्रासफल correct कर्तव्यह्रासफल see this is very pertinent one dharma adharma if we include both then naturally adharma abhibhava so that will be there dharma will be subdued that problem is there and for that all the houses of law they are there to protect it and to decide what is dharma So very good question, sir.
There is one more interesting reply.
Please.
There is one more interesting reply. When untrue statement is justified despite adharma, I am more than confident you know it. What has been said in Mahabharata about this? Do you recollect? If you are likely to save somebody's life, which can't be regained by any method, and you make a lie, make a false statement and you save it, iti papaha nasti. Not that every time adharma is sin. Sthalakala paratve nirnaya asti.
Excellent, sir. Sthalakala paratvena nirnayo asti. So that is justice. So, and the problem is that in one time we think that this is dharma, and in another time it will be proved that it is adharma or vice versa. So that's why sthalakala nirnaya, that is great.
Therefore Vivek.
Therefore Viveka. And that Viveka also depends on the justice. Because we all have our own Viveka. But when we approach the house of law, then that Viveka is the higher one. Like Uttarottaram Pramanyam. So we approach that and that proper justice will be delivered. So this way we suppose that dharma is sustained. But in some of the cases recently we have observed that some courts have interfered and society has a different understanding of that. Society shares a different feeling and court has given a particular decision. So there was a conflict also. But in such cases mostly it is held that you require some time to understand the justice delivered. Please, sir.
Only one sentence. Society feels something is perception than on evidence. So don't worry.
May I say something, please? Yes. No, one thing also, related to what you are discussing now and also on the topic Dharma Shastra and real world implications is the issue between the relationship between morality and legality. For instance, in Western countries, many laws that were considered illegal have been revoked. For instance, divorce law, then abortion, now euthanasia, issues, many issues related to bioethical problems. So sometimes the religious books are clearly, but the society issues laws that are legal, but perhaps can be considered immoral or can clash with morality. All the discussion about abortion now in US recently, etc. So how present is this discussion also in the Dharma jurisprudence?
It again banks on Vivek. I'll give one Jatak Katha illustration. One Shudra was eating meat of a dog, dead dog. A Brahmana came and gave him advice that it is sin to eat meat of the dog. He was driven to throw it away. And then that Brahmana picked it up and ate it itself. It was a case of life. Viveka was sharing, not eating himself. But he did a sin, but it was justice in the given situation to save one's own life. Justifiability is one thing. Morality is again fantastically fluctuating thing. I'll give one small example, not to be explained more than that. Single act of adultery is a ground for divorce in Christianity. Under Hindu law, living in adultery is required. Single act is pardoned. It is morality compromised being inevitable part of life. And Manu also says, don't leave your life partner alone to be susceptible for losing the character. So he recognized some such possibility. So morality is not a glass pot which can be broken, which is a metal plot which can be welded. So don't be so touchy about morality.
Great, sir.
Is there any law for euthanasia in modern legal?
One word answer is sufficient. Paryupavation.
Yeah,
Paryupavation.
in some countries it is not prohibited, but in some nations it is prohibited. Yes, ma'am?
My question is to Joshi, sir. Can I ask?
Yes, please. Please.
Do you think that there is any difference in the perspective of the Western jurisprudence and Indian jurisprudence as far as punishments are concerned?
Great, wonderful question. Entire Western jurisprudence, as I mentioned, is based on material life. Thematically, they say that guilty mind is to be punished. Right? Guilty mind is to be punished. But the device of punishing guilty mind is the guilty body. Therefore, corporal punishment. The concept of dand is distinct from concept of paschatap. Chitta is to be penalized, not the body alone. So if chitta gets penalized and the guilty person prays for kshama yachana, what is stated in the Ramayana is reminded. Rama says to Lakshmana that if even Ravana comes and prays for apology, I shall pardon him having committed such a great thing for which a war was invited. So Western penology is based on corporal, that is bodily punishment, except the philosophy of reformation, which was evolved in England last 100 years before. Indian philosophy is paschatap, chitta shuddhi. That is the... Yes, chitta shuddhi. Have penance. Punish yourself. Learn from penance, eliteness. And you are above all these things. You become a normal man thereafter. So Valmiki, Valya becomes Valmiki. Chitta Shodhana. This word Shodhana is mostly not understood. I don't say misunderstood. Shodhana, इस शब्द का धातु ढूंढो तो मजा आएगा. चित्त शोधन है.
Yeah, very beautifully presented, sir. Shodhana, that's from Shuddhyati, Shuddhi. So, and as you said, remember one incident that Mandana Mishra, the great example of Mandana Mishra. So when Shankaracharya approached, by the time he was already ready for the expiatory act, and he was ready to sacrifice his body just because he had wronged towards the teacher. So the punishment he had taken upon himself was just leaving the body, sacrificing himself. So such kind of, as sir said, psychological punishment, not physical, but in the ancient texts like Smriti Grantha, we find both.
With the body. So it's not psychological. Chitta Shodhak.
Chitta Shodhana. Yeah. And I ask Kashinath sir, have you got anything to share on this topic?
Just I want to add previous one that lawyers about the in Mimamsa and Nyaya in all Indian philosophy they take these things like Vishayo Vishayasaiva Purva Pakshas Tathottaram Nirnaya. This is five. So Vishaya subject, Vishaya sansaya and doubt, and Vishaya sansaya Purva Paksha previewed and Uttara Paksha and Nirnaya. Then only Nirnaya. Purva Paksha, after Purva Paksha and then Uttara Paksha and then Nirnaya. This.
Linguistic addition. This word Vishaya requires deeper insight. I am not saying study, you are all learned people. Deeper insight. Vishaya has got inbuilt ashaya in it, and ashaya has got an object in it. So unless you get to the roots of the object, you cannot arrive at a conclusion. So assistance of an elite or a learned person in the fields. In the field, if it is a case of horse trader, and horse trader is a good mediator or counsel. If it is goldsmith, a goldsmith is a good person, not otherwise qualified lawyer. The very emergence of the concept of modern lawyering is a fallout or byproduct of modern court system, which is again based on material things. That's all. Thank you.
Yeah, since this is topic of Adhikarana, I remember in Mimamsa we have 1,000 topics. So it is Sahasra Adhikarana text. And there it is actually from doubt to assertion. So it starts with a doubt and it takes us to the assertion. Yeah. And all the Sanskrit persons know that Pratijna, that should take us to Nigamana. So in Pratijna there is doubt, Sandeha. And in Nigamana, There is no doubt because it is asserted. So that kind of, that Panchavayava, the 5-membered syllogism, if it is properly employed, then Prakarana will be complete. Vishayo, Vishaya. One Vishaya is subject and another Vishaya is Samshaya. So, a lot of discussion is there even in Advaita. Madhusudan Saraswati has put for that whether Samshaya becomes the Anga of Vichara. Samshaya se Vicharangatvam asti nava. Vicharaha. Vipratipattehe Vicharangatvam asti va nava. So such discussions are there, very deep, and all the scholars here know that a complete session should be dedicated for that. How an idea is taken into a theory. Otherwise it's only an idea. But if you give logical strength to that, it will become a theory, an established theory. So this is really good panel discussion, and I appreciate all the learned scholars here who had actively participated in that, and other youngsters might have received some inspiration from this. And that is actually the purpose of this panel discussion, that who are new to such discussions should be encouraged and engaged in such discussions so that this legacy will continue. And